Good afternoon, everyone. My name is Shelly. Thanks for your attention. My topic is about trademark infringement. As you know, it is a rather complicated topic. Today I just give a brief introduction on it. My topic is made up of three main parts. The first is 10 infringement acts. The second, infringement defense. This part means that if someone is accused of trademark infringement, what kind of reason he can based on to protect his own rights. The third part means that then the third disposal method. Now let's go to the first part, 10 infringement acts. Five of them are regulated by the Chinese trademark law. The first, using a trademark which is identical with or similar to the registered trademark on the same kind of commodities or similar commodities without a license from the registrant. The second, selling the commodities that infringe upon the right to exclusive use of a registered trademark. The third, forging, manufacturing without authorization the marks of a registered trademark of others, or selling this kind of trademarks without authorization. The fourth, changing a registered trademark and putting the commodities with the changed trademark into the market without the consent of the registrant of that trademark. The fifth, causing other damage to the right to exclusive use of a registered trademark of another person. And two of them are regulated by implementing regulations of the Chinese trademark law. And the first, to use any design which is identical with or similar to the registered trademark of another person on the same or similar goods as the designation or decoration of the goods, which mislead the public. The second, to intentionally provide facilities to the person who made trademark infringement. Three of them are regulated by the judicial interpretation by the Supreme Court. The first is the use of words identical with or similar to another registered trademark as a trade name in a distinctive manner on identical or similar goods and cause people confused. The second, the copy, imitation, translation of another's well-known trademark, and on similar, identical goods and cause people confused. and possibly causing damage to the interest of the well-known trademark owner. The third, the registration of words identical with or similar to another's registered trademark as a domain name, and to conduct e-commerce in the goods through this domain name, which is likely to cause people confused. And then we'll come to the second part, infringement defense. When someone is accused of trademark infringement, what kind of reason he can turn to for help to protect his own rights? The first, not identical or similar. When someone is accused of trademark infringement, he can argue that both of the words are not identical or similar. How about identical trademarks? Perhaps you can see the next two pair of trademarks, and the Wudomi, and the right and the left trademarks. So you can see that identical marks means two marks. That two marks don't have much difference, and almost the same. Yeah. How about similar trademarks? 玫瑰花 and 玫瑰太阳南太阳 generally speaking, the similar marks means two marks have much sameness that would let people confused or mislead the public. But to judge whether trademarks are similar or not, it is not an easy thing. Let's go to see the next two pair of trademarks. 嘉裕长城 and 长城牌. Do you think they are similar trademarks?
No.
Yeah. They look quite different, but actually they are deemed as similar trademarks because 长城牌 is a well-known registered trademark and has been used for many years. So 嘉裕长城 is refused by the CTMO, the China Trademark Office. Now let's Now let's see the next pair, CYTS and CITS. Do you think they are similar or not?
No. Not really. I mean,
Yeah.
I'm quite particular about this one.
Yes.
It sounds CICY. It's kind of close, but you say, look at it.
Yeah.